Good afternoon, ladies and gentlemen. My name is Grayson Chester. I'm one of the attorneys here at Rehberg Law Group, and I am joined here by my friend and colleague, Mark Reinhardt, who's also one of the attorneys here at the firm at Rehberg Law Group. And today we are going to talk to you about life insurance planning and how this relates to your estate planning goals. Now, the purpose of this conversation is to situate us around some of the unique planning concerns that come up with life insurance that are not all that common with other assets. There are some unique features here with life insurance specifically that we need to talk about to make sure that we understand what those issues are and how to best think about using other tools to help solve or at least address those types of planning concerns. Now, before I go too far into the weeds here, I want to make sure that we're all well situated about what this seminar is going to be and what it isn't. This is not a general estate planning seminar. Most of your general estate planning goals happen through your will or your living trust, which of course, at a firm like Rehberg Law Group, that's mostly our bread and butter. We do that type of planning almost exclusively, whether that be on creating the plans or actually administering the plans at death. So these types of concerns now that I'm going to bring up, talking about life insurance, are the types of concerns that we need to think about now that we already have the core of our plan in place, whether that be a will and a living trust. Either one of those types of plans can deal with the core of our major estate planning concerns. Now, for this life insurance type question, we're going a little above and beyond. So this assumes that we have a little bit, not much, but a little bit of basic fluency about what a trust is and about what an estate is, the basic concepts here for estate planning before we are actually now able to speak in a lot of detail about the specific planning concerns to deal with life insurance. Now, with that in mind, let me begin the screen sharing here so I can actually have the PowerPoint slides up and ready to go. Bear with me for one moment.
While Grayson is working on the technological aspects of all of this, I'm Mark Reinhardt, and it's often said that the only thing worse than death is to spend an evening with an insurance agent, a life insurance agent. This isn't going to be that, of course, but keep in mind, Grayson and I, we don't make any money on insurance. This is going to be one of the few times you hear somebody talking about insurance at this depth, where we're not trying to get a commission out of it. And as Grayson pointed out, this is a type of plan that would be there in addition to your basic estate plan. Grayson, we used to see maybe, I don't know, 5 to 7 irrevocable life insurance trusts that clients would ask us to do maybe in a year of all of our clients. That number's gone up a bit. And do you have a sense of why that might be?
There's a lot of concerns here motivating people to do more specific planning for their life insurance. And one of the biggest ones, if I had to choose just one, is the fear of uncertainty. We're going to be talking about this in a little bit more detail here in the coming seminar here. We've got some specific slides on this, but there's a lot of potential changes here in the not so distant future for how the estate, gift, generation skipping, transfer tax, and maybe even income tax laws could potentially evolve and change such that what you have in place now might work under current law, but with future changes here, this uncertainty, this unknown, those issues could frustrate the plans that you have. And so for a lot of people who are worried about, say, falling exemptions, the idea that more of their estate would be subject to estate tax, or higher rates, right? The idea that that portion subject to estate tax is going to be taxed at an even higher amount. These moving targets here will often spur people to do a little bit more proactive planning to help hedge their bets. And that's the core issue here that we're talking about, is to get a little bit of certainty about what this might look like, even in the event that 1 or 2 or 3 unexpected law changes might be there down the pipeline.
All right, sounds good.
Now, with this in mind, before I begin the seminar in earnest here, please be aware that we do have a chat function. And if you have any questions that come up as we go through this material, Mark and I are going to tag team this. Really, every slide or two will change off. We want to hear from you to see if there is anything here that you wanted us to discuss in a little bit more depth. I will be looking here through the chat to see whether any questions come up. And as best as we can, we will try to integrate those questions as they arrive into our presentation. We'd like this, as best as we can, make this live, right? This is not a pre-recorded seminar. We don't have, a fixed set of things that we need to go through necessarily today. We want to hear a little bit about you and your goals through this chat feature to see if there's a little bit we can, focus this more on, if it's more relevant to you that way. So with that in mind, let's move on past the introductory slide here. And I'm assuming, please tell me in the chat if this is not the case, that you are all able to see these slides right now. So right now, we're on the very first slide, table of contents, and I just want to briefly talk about what we're going to go through today. So this issue that we're planning around using life insurance, and really most other estate planning tools as well, all hits at this fear of potentially having estate tax liability at our death, whether that be at the first death or second death, potentially for a married couple. Right? Sometimes these concerns don't happen just immediately after one death. It could be something deferred for the future, right? That it's only going to happen at the death of the second spouse. But either way, this concern for estate tax planning, how are we going to pay that estate tax bill, is a very, very hot topic button. One of the big concerns here is that payment, of course, has to be made in cash. You have to actually pay the estate tax bill with liquid monies. That means you don't get to simply distribute 23.86% of a piece of closely held business or real property in order to pay for it. That cash bill is actually in cash. And so there's a big concern about where that money is going to come from. Do we have to liquidate some business holdings, some real property, some closely held assets that we would not otherwise have wanted to sell solely to pay this bill? And all things equal, if you were to run into that type of problem, that's the default answer of yes, that tax bill is now due 9 months after date of death. And neither the state of Washington nor the federal government give much care about the difficulty to liquidate an asset to come up with that bill. Now, when talking about this liquidity problem, life insurance has traditionally been just on its own a very, very good tool to help, not to solve, but to help with that type of planning concern. Now, as you see here on item number 2, we suggest that might be the wrong solution, or at the very least, perhaps an incomplete solution to the problem. Yes, life insurance will have that explosion of death benefit. But if that's all we're talking about here, that death benefit itself might have some tax concerns, some consequences that we would have to deal with at that time as well. And so what we will be suggesting here over the course of this presentation is that we should generally consider having maybe a little bit more than just the life insurance itself, but perhaps some tools here in addition to the life insurance, maybe even owning the life insurance policy instead of us, in order to use that policy, that death benefit, to accomplish as much of these planning goals as we can without some portion of that death benefit potentially having to go to pay taxes too. Now, I will hand over the podium to Mark.
Yeah, thank you, Grayson. So as Grayson mentioned, a big part of the reason that people are turning to irrevocable life insurance trusts, and a big part of the reason that they are even looking into life insurance, things like that, is looking ahead to estate taxes. They're trying to find this pool of money that will be there in case estate taxes are due. And this pool of money, since it's cash through the death benefit of the life insurance policy, means that we're not having to liquidate a business, we're not having to maybe sell a house in a down market, or we're not having to use part of our IRA money that we wanted to go to our children and have them have to cash it out, pay the income tax as they take the IRA money out, and then pay the estate taxes with that amount of IRA that's thereafter they paid income taxes. So let's at least make sure we're all on board with what the heck are the estate taxes right now. Now, estate taxes have always been known as a tax on the privilege of passing money after you die. It is designed to kind of punish anyone who's over a certain amount of money. I often talk to my clients and compare it to a limbo bar. Just like a limbo bar, anything under the bar, there's no tax, but anything over that bar, that's the part that's taxed. Fortunately, the federal government and the Washington State Department of Revenue both have that limbo bar set relatively high, but we're going to look at what those are. So the basic idea is what we're calling transfer tax after the 2019 Tax Cuts and Jobs Act. This would be the gift and the estate taxes. These are coordinated now, so that if you give away a certain amount of money after, while you're living, depending on how you gave it, that may come out of your estate tax exemption after you die. In any event, the limbo bar is very high. It's at $11.7 million right now. So if you give away in life or death less than $11.7 million, then we don't need to worry about estate tax at this time. That assumes you die soon, tomorrow, the next day, certainly before Congress passes new legislation. Anything above 11.7 million will be taxed at 40%. There's also another type of tax that Grayson briefly mentioned called a GST, or generation skipping tax. The government doesn't like it when people say, well, I'm going to put things away for my family forever. They don't ever actually get control of the money, but it's there for their benefit. This is what the Kennedys and the Rockefellers did many years ago. They basically put all of their children's money into basically forever trusts, and the kids never got any of the money directly, but the money could be used for their benefit. Then when Nelson died, or Robert F. Kennedy died, whoever, then there's no additional estate tax at that time. And the government finally in 1986 said, enough. We're going to make sure that people can only give so much away into a trust that effectively skips more than a generation before it's liable for estate or gift tax. So right now in your mind, big picture, just think, look, it's 11.7 million. I don't need to worry about that, right? What am I even doing watching this seminar? There's probably something great on Netflix right now. Maybe I'm a little behind, right? So keep in mind, though, these things are going to change, and we'll look at that in a minute. These numbers are never written in stone. They are always written on the latest back of the envelope that Congress has decided to use. Now, there is another potential advantage right now, and that is that each person who's married, if their spouse dies and they don't need to use that full $11.7 million exemption, suppose your spouse dies and they only needed to use $2 million. They had a $2 million estate. What happened to the rest of that 9.7 million? 2 million is 9.7 under 11.7 million. And not too long ago, the federal government finally said, okay, if you make certain elections after the first spouse has died, we will allow you to kind of bank or import, keep that unused deceased spouse's exemption and then use it when you die. So if you made the right elections, you could take your deceased spouse's unused exemption amount, which in our example, 11.7 million minus 2 means we have an unused exemption amount of 9.7. Then you could sort of say, I want to keep that. I'm going to claim it. And then when I die, I can add my deceased spouse's number to my own. And then depending on what the numbers are when you die, you may have well more than what you need. So that's the good part of everything. The good part right now, the federal level, the exemption is very high. And we also, for married couples, have this idea where if you make certain elections in a formal way, we can have portability. Let's turn then perhaps to, let's turn to the next slide, please. All right, so the bad news is that Washington State also has an estate tax. And it's very different from the federal government's tax. Many of you who did your planning prior to 2006, if you're married, please come in and see one of us, because in all likelihood, your plan doesn't think about what happens if there's a Washington state estate tax. So Washington state in 2006 put in an estate tax. The exemption at that time was anything over 2 million. It's now, after some 15 years, it's risen to $2.193 million. The exemption has been frozen a while at that number because the Department of Revenue is using a technicality to avoid raising it with cost of living. Anything above that number is taxed at 10 to 20%. So you think, well, that's not very high. That's not a big problem. Let's look at this in a little bit. The first problem is there's no portability in Washington state. So unlike the federal government, if your deceased spouse doesn't use their entire exemption, you can't save it up for later with any kind of exemptions. It's a use it or lose it situation. Suppose we've got a couple, Morton and Melinda Middleton, and basically they have a $4.2 million estate. They don't do any planning, or the kind of planning they have is the basics, right? When I die, I want everything to go to my surviving spouse. I call that an I love you, honey plan. Many couples, when they first get married, they have a child or two, this is the plan they put into place. And they put it in place mostly because they wanted to make sure there were guardians for their kids. You know, we want our sister and then maybe our neighbor to be the guardians for our children if we're gone. That was the big reason they were putting in this plan. But now, some 20 years later or more, those kids are grown up. They don't need guardians anymore. They may need help. They may need somebody to keep them on the true and tried path, but they don't need a legal guardian. And this couple still has this plan where everything goes to the surviving spouse. So in Washington state, we had a $4 million or so, everything ends up with the surviving spouse. So let's say it's Melinda. Now she passes away. She's at $4.2 million when she passes away. That means she's $2 million over the Washington state exemption amount. And that would result in the way the progressive Washington state estate tax works in $240,000 of estate tax. We've had clients who have real estate, they've got IRAs. Yes, IRAs are part of your taxable estate. They have life insurance, and we'll look at why that's part of your taxable estate. They have cars, they have furniture, you name it. If you have some kind of ownership ability over this, it's part of your taxable estate. And we've had clients who come in, maybe they're with a couple, they worked at, a long term, they've got a nice brokerage account, they have a house or so, life insurance, they've got some retirement accounts, they're worth 8 million. You're quickly looking at $700,000, $800,000, $1 million or more in Washington state estate taxes. So these things will add up very, very quickly, even under the current tax regime. So that's the background on what we're looking at right now. But now I'm going to turn it over to Grayson, and he's going to paint a very dark picture for us coming up ahead.
Thank you, Mark. So next up here, the ugly. And this is going to get into some of the fears that even some of you may actually already have before even having tuned into this meeting. These fears are about the uncertainty in these transfer and income tax systems that we have, about what might this look like here in the coming next few years even. This is not the so distant future anymore. This is something that could very well happen, maybe even as soon as next year, and certainly as things are currently written by 2026. So this is something that's actually become very, very hot button. This is a major planning concern right now for a lot of folks dealing with the fact that they may, based on those laws, have no estate tax at all, or if the laws fall, potentially have hundreds of thousands of dollars in estate tax. And that uncertainty is the ugly. So let's first talk here about this hypothetical couple, Jay and Daisy Gatsby. We're going to pretend that they have $10 million between the two of them. And if they have no estate tax planning, as Mark just mentioned, an all-to-spouse-based plan, which is what Washington presumes you will do in most cases if you have no planning, effectively throws away one of the two spouses' exemptions. That is to say that if Jay passed away first, leaving everything to Daisy, Daisy will have both halves of the estate with only her own one Washington state exemption to actually use to cover those assets. Even though the married couple each got their own card, the first spouse effectively threw his or hers away. And that means just on the Washington side alone, the consequence of that plan for a $10 million estate will be at least $1.25 million. Now let's talk about what the federal government might have to say. Now I want to make sure that we understand that we are not editorializing this as best as we can, saying that one political party is going to come after you and the other are the absolute defenders of your money, because that's not true. The reality is that both of the political parties have plans right now to claw back some of that exemption, to say that at some point we're going to lower that exemption. It's currently 11.7. The Republican tax plan in 2017, already the law of this country says in 2026 that it's going to be pulled back down to $5 million indexed for inflation as of 2010, which we're thinking now as practitioners is probably going to be around, we hope, $6.5 million or so. That means the Republican plan, as already enacted, is to reduce the exemption from 11.7 down to about 6.5 beginning in 2026. The Democrats have proposed various plans here, ranging from an exemption of maybe 5 million all the way down to potentially 3.5 million. And we're talking about rates potentially starting at not 40% anymore, but maybe 45%, potentially even higher than that. Bernie Sanders, for example, ran very strongly on a 77% tax on over, hundreds of millions, on billions, right? The idea that this being actually a progressive system, not just a flat tax of 40% on anything over the limbo bar. So with that in mind, let's actually take a few of these ideas. Let's assume, right, if the sunset occurs under the Republican plan here, that it's going to be 40% over 6.5, or under the Biden plan, right, that it would be 45% over 3.5. In both of those cases, you can see here the result of that falling exemption. If that exemption hadn't ever fallen at all on the federal side, they wouldn't owe any federal taxes. But if it falls now, based on the Republican plan, the 2017 Tax Cuts and Jobs Act, they will owe almost $1 million additionally just on the federal side alone. And under Biden's plan, right, under the Democrat plan that we're talking about here, it's a little bit of a moving target because it hasn't been formally proposed just yet. If we assume 45% over 3.5 million, that's an additional 2.4 million of taxes on top of the Washington taxes as well. So what we're saying here is that that $10 million estate under either of those plans, right, under either of these situations happening on the federal side, will probably owe between 2.1 and $3.6 million of estate tax, both Washington and federal combined. That's a pretty big range here. That is $1.5 million of difference, simply because we don't actually know. And that's the true reality here. As practitioners, we can make our best guesses about what the future might hold. But at the end of the day, we may be wrong. And practitioners have been wrong many, many times before in the past few decades about what they expect the law changes are going to be. So with that uncertainty in mind, that danger zone, let's move on here. And we're going to talk about specifically why life insurance, just held on its own, could potentially worsen that problem, may not actually solve very much for us at all. Mark.
Right. Thank you, Grayson. So it's to paraphrase President Eisenhower, 1 million here, 1 million there, then pretty soon you're talking about real money. And so it's important when we're trying to now turn this to this is the estate tax world we're living with. as Grayson mentioned, with a lot of uncertainty, to, okay, what can we do about it? What are some tools that are available? And many people think, you know what? I'll get insurance for this. So suppose the Gatsbys we saw in the last slide, they were going to owe between maybe $2 and $3.5 million at estate tax. And they think, bingo, let's go to our life insurance agent and let's get a second to die policy. In other words, the policy doesn't pay off till the second of Jay and Daisy pass away. So the premiums tend to be lower. They pay for that. And then at the end of the day, right, they're thinking, okay, now we'll have this big pool of money available to pay off whatever the estate taxes are. We need to kind of dive in a little bit to the policy. What are some of the terms that are there? And most of us, when we get a life insurance policy, we're not really worried too much about who's who. All we're worried about is how much is it and what's the death benefit, right? That's it. Can I afford it? And will this be enough down the road? But we need to break a little bit further into the darkness here and look at this, because there are different actually parties, let's call it, in a life insurance policy. The first party is the owner of the policy. In other words, the person who takes out the policy and the one who is paying the premiums. That's someone who's known as the owner. They can always, of course, down the road, they could change who the beneficiaries are. They could stop paying the premium. They could say, I don't need this insurance anymore. Or they could say, you know what, I'm just going to cash it out. There's a cash value, and I just want to cash that out and buy my cabin somewhere on the coast of Belize. So they could do any of those things. That's the first party. The insured is the person on whose life the policy is. So you say, okay, I'm the owner, but whose life are we insuring? Maybe I take out $1 million on Grayson's life and say, I want to insure his life. Then when he dies, right, pay me $1 million. Or he looks at me and says, Mark probably doesn't have that long to go, and he could do the same. Many times with couples, right, it's one spouse talks to the insurance agent, they're the owner, or the couple is the owner, and it's one party or the other who's the insured. It's on their life. With a second to die policy, this would be on both lives, Jay's life and Daisy's life. It doesn't pay out when the first of them dies. It pays out when the second of them dies. So that's the second party, is the insured. And the third party is someone who's the beneficiary, maybe someone or other entities, a number of people, but basically who gets the death benefit from the policy? For that $1 million policy that I took out on Grayson, who did I say gets it? Or for Jay and Daisy, right? Who did they name as the beneficiaries? Did they name their kids? Did they name their estate? Did they name, their creator? Just depends. Who's there that they could name as the beneficiary of that policy. All right, with that background, let's look at then some more background about a life insurance policy. Next slide, please. Now we're focusing, of course, in this seminar on one type or one basic reason. But remember, you could still say, you know what, I'm not worried about estate taxes, but there still may be other reasons to consider having a life insurance policy. Number one, many times people use this to try to equalize their kids' inheritances. Maybe one of the children has really been involved in the business, and this business is now worth, let's say, $6 million. Well, wait a minute, the business may be about the entire value of the estate. If you want to give the business to that son or daughter who's been heavily involved with it, what's there for everyone else? Well, you may investigate life insurance to try to make sure that there's money both to the person who's helping with the business, you want them to have it and run it, but also make sure there's money that equalizes things for the other child or children. If you're involved in a business yourself, then you may have, some kind of an agreement with your other partners where if one of you dies, how am I going to buy that person out? How do I make sure that I'm not a co-owner with their kids, or their long lost aunt, whoever their estate plan says. So many people have agreements that are known as buy-sell agreements. And these types of agreements, you basically need to make sure there is money there to pay off that deceased partner's estate, to make sure that we don't have to worry about, oops, we have no money, we're going to have to mortgage the business or sell the business in order to buy you out. It could be the classic situation would be income replacement. You have one spouse or the other, they're making the money. And then if they die, what's the other spouse and the kids going to do? So you have insurance to serve as that income replacement if a spouse dies. Of course, wealth replacement just means, look, I want to make sure that if something happens, I have this pool of money that's available. And finally, what we've been focused on, that pool of funds to pay estate taxes. And many people then turn to life insurance and they go out and they get some life insurance. Let's suppose, for example, that Jay and Daisy Gatsby, they say, I'm going to get a policy for $2 million, right? Mark and Grayson just seem to say that's about the money we'll owe. We think that'll be the worst case scenario. So they go to their local life insurance agent who's only too happy to have a second to die policy written up, and it's in their names. So let's turn to the next slide, and Grayson will tell us maybe the Gatsbys or their kids have a surprise in store.
Perfect. Thank you very much, Mark. So this is what we've been hinting at now since the very beginning of the presentation, that life insurance owned by you on its own could have some potential pitfalls here when it actually comes time to pay out that death benefit. Now, this may come as a surprise to many people because we have been told in just common parlance the exact opposite of what I'm about to say. So to be clear, life insurance has tax consequence to it. There could very well be tax owing on the death benefit itself. Your ears should be ringing right now because you've probably heard before that there are no tax consequences to life insurance, that life insurance death benefits are tax-free. It's a great way to bring a tax-free asset into the name of your beneficiary. So why is it that you're now seeing a young attorney's face here challenging that view? Well, it's because the Internal Revenue Service, the Treasury Department, and more specifically Congress in 1954, that old, has always said that the death benefit of your life insurance policy is actually included in the value of your gross estate. If you don't believe me, look up Internal Revenue Code 2042 and tell me what it says. It's very, very clear. It's inescapably clear. Now, most of what we've been told about the tax-free consequence of estate or of life insurance policies is on the income tax side, and that's exactly true. There are very little income tax consequences, if any at all, on that death benefit. It is not taxable income to your beneficiary. But that's just an income tax answer. It's not a transfer tax, or specifically an estate tax answer, where we know for a fact that the entire value of that death benefit will be taxed to you in your estate. So hypothetically, if you are, say, a few $1,000,000 over the federal estate tax exemption, and you have now a $2 million death benefit on life insurance, 40% of that $2 million will disappear for estate taxes. So if Jay and Daisy had a $2 million death benefit, thinking that they were going to have to use that $2 million to pay the $2 million or so estate tax bill, 40% of it just disappeared overnight. We're talking about $800,000 of that $2 million they thought they were going to have is gone within 9 months of date of death, solely because the death benefit of a life insurance policy is included in your taxable estate. There are only a handful of ways to actually get around this, and that is exactly what Mark and I are going to be talking about here in the coming slides. Now, This slide here is the unexpected beneficiary. This is to say that 800,000 in that scenario is going to go to someone else, not to your beneficiaries, not as a wealth replacement tool, not as even a means to be available to pay this estate tax bill. It will go to the state and federal government. That very, very large portion of that death benefit isn't even going to be there. The Department of Revenue in Washington and the IRS on the federal government will get their fair share. And on an estate tax return, you have to report this to them. You have to provide all of this evidence about that death benefit policy. So it's very hard to even hide it from them because the insurance agent is providing the same documentation to the IRS and the Department of Revenue as well. It's very, very tough to get around this one. Now, Mark will take over and begin talking about one of the tried and true methods here for helping solve this problem, to make sure that we have the benefits of life insurance without that potential that 40% of those benefits themselves will disappear too.
Yeah, thank you, Grayson. Can you go back one slide? I just want to touch on a few points. Number one, everyone, remember what Grayson was talking about with that 40% is the federal level only. If you were to add $2 million to Jay and Daisy Gatsby, they're already, remember, at 10, then by the time you have the state tax, because clearly 10 is more than 2.2, and you then add the federal tax, actually it comes out to a little bit north of $1 million of tax on that $2 million. So you may have done that where you had your sibling and you said, hey, cut the cake in half or cut the dessert in half. You get half, I get half. One of you picks it. In effect, what Jay and Daisy have done is they've given the government the first choice. They're going to slice that insurance death benefit proceed in half. And now they have two unintended beneficiaries they never named, two uncles. In fact, Uncle Sam and Uncle Jay will get half of the insurance premium. And that is because that Jay and Daisy kept certain rights over the policy themselves. They basically had so much control over it that the federal government, as Grayson said, they're going to treat it just as if Jay and Daisy owned it and it's their money, even though this is a second to die policy. Jay and Daisy didn't have an extra $2 million sitting around somewhere. They never really thought of that as an asset. It only was paid out when the second of them died. But the federal government says, you know what, if you have ownership, which Jay and Daisy did, remember they were the owners of the policy, they paid the premiums and they retained what are called incidents of ownership. That's more or less the ability to enjoy the policy in some way. You can change the beneficiary, right? If you're mad at them or you decide you want one cause or person to get more than the other. You could transfer the ownership of the policy. That's another incident of ownership. You could use the policy value as a collateral for a loan, or you can just get any kind of benefit from the property. So even though this doesn't exactly match, I typically use the acronym PIE. If you can eat your pie when you die, it will be part of your taxable estate. And PIE is short for possession, P for possession. That means they're the owners. I is for income or incidents of ownership, which is those kinds of rights to change things. And E is enjoyment. Can they change use the policy in some way as a loan collateral or take the cash value or change beneficiaries, you name it. And so, of course, in the Gatsby's case, they kept it, right? When they died, they had the right to the pie, which means the government slices it in half and they take the first half. All right, thank you, Grayson. Let me go on to number 3. So we learned then, as Grayson pointed out, owning the policy, if your real goal is to try to maximize the amount that's going to your beneficiaries or maximize the amount that is there for your that pool of money to be there available for your executor to pay estate taxes down the road, then owning it in your own name, having control of it, being able to change things or pay the premiums, those are bad ideas. Well, now what? What's the point of this session? Why am I watching this? How can I not, is there any way I can have life insurance and do this? Can I have my pie and eat it too? And the answer is yes. But like many things, we need to have a special vehicle that allows you to not be so directly involved with things. You can set up a trust to own the policy, and a trust is the beneficiary of the policy. Remember, we talked about the owner. Instead of the Gatsby's being the owner, the irrevocable life insurance trust is the owner. They can still and are the insured, of course. The insured, their lives, this pays out when they're both gone for Jay and Daisy. They're the insured. The trust is the beneficiary. So they're not giving this money directly to their kids or to their estate, or they don't say specifically in the policy for the payment of my estate tax. They can say it might be, but not it shall be. The bottom line is we have a solution for all of this. We can have all of that $2 million policy be available and outside of the government's hands at the end of the day. That's an ILIT. Let's turn to the next slide, please. So, okay, here's this ILIT, one of the many four-letter acronyms we use in estate planning. I don't know why we have so many with 4 letters, but we do. We've got, we're going to talk about another one later on in this. But an irrevocable life insurance trust, an ILIT, how would we do this? What do we need to do in order to create something like this? Step number 1 is to create the irrevocable trust. It's very important that we name an independent trustee. That means not the owners. Jay and Daisy should not be the trustee of this trust, because then they could control it and they might have some incident of ownership over the trust. So maybe they name one of the kids, or they name a friend or a brother, something like that. They also create the irrevocable trust and they say who the beneficiaries are going to be. Equal shares to my sons, or equal shares to all of my kids, or even grandchildren down the road. And just as you would do in your will or your living trust, you're deciding where this money goes and how down the road after you're both gone. After the trust is created, then the trust purchases life insurance on the lives of the trustor, or both, Jay and Daisy being trustors. They created it. So the trust purchases the life insurance from the get-go. That's ideal. And now the trust owns this life insurance policy. There's an independent trustee who's in charge of this trust, and then we know who the beneficiaries are going to be down the road. And the ILIT, of course, is the beneficiary. So we've managed to make sure that possession and incidents of ownership, enjoyment, all of those things, because this is irrevocable, it's outside of Jay and Daisy Gatsby's control. They can't get cash out of it. It's not there for their benefit. They don't have the pie when they die. It actually is going to be in this trust for other people. Next slide, please. All right,
Okay.
so the reasons for creating an irrevocable life insurance trust. Let's let Grayson handle this, because I've been talking a lot lately. Grayson, why would we want to create one of these?
Perfect. So as Mark summarized here, one of the biggest benefits that we're trying to hit at is that we want to make sure that the death benefit of this policy, the whole reason that you were having this policy in the first place, isn't going to simply increase the estate tax bill. That policy is not going to have its own set of estate taxes on it too. And as Mark corrected, that was a good clarification here. It's not just the 40% federal tax; it's the blended. Now we've got 20% here on Washington side too, maybe, right? So on top of that, we could be talking about half of that death benefit policy or more being taken away by the Department of Revenue or the IRS just for transfer tax purposes. Now, that means, of course, that if we are able to avoid that, we haven't just avoided the estate tax hit too. We've also basically doubled the amount of coverage. And that's going to sound a little bit backward. It's the exact same amount of coverage that you always thought you had, but now you actually get it, not just half. Likewise, there are ways, which Mark will talk about here in the next couple of slides, I believe, to even fund this ILIT, to continue paying the premiums here in such a way that we may be able to avoid much of, if not all of the, maybe even the gift tax results for having done so. As you may have heard, you can give now, as of this year, up to $15,000 per person per year without ever having any gift tax consequences. It's tax-free, and you don't even have to file a form to prove it. And in ILITs, there are ways to get that as well. So it's possible, we'll talk in a little bit more detail here, that even the gift tax consequences for using an ILIT as the means to solve these problems could be off the table too. The other big issue here, one of the other major concerns, is that it allows you to control the value of those life insurance policies after your death. Now, a beneficiary designation generally is pretty simple, maybe even simplistic. If we say to our spouse or to our kids, that's what it means. There's not a lot of language you have to read into. It means that it is theirs. And if it is theirs, they can take it and use it however they want. If they go through a messy divorce, that death benefit that's now in your child's pocket, for example, is subject to the divorcing spouse. There's not a lot of protections that we can have on here too. So having a life insurance trust allows us to plan with a lot more specificity about what it is you actually want your death benefit to do. And then finally, if we do have a liquidity problem, if the government says that we're worth enough to pay estate taxes, but we don't actually have the cash at hand to pay them at our death, well, using an ILIT can provide a lot of flexibility here. To be clear, the ILIT can't actually say, yes, it has to pay estate taxes. That blows up the whole plan. But simply by giving the liquid proceeds to your beneficiaries can in turn choose to use those liquid proceeds to swap assets out to help solve this problem, so that ideally the business interest or the family cabin or any other closely held asset like that wouldn't have to be sold simply because the government wants its tax bill. That we can have this replacement, some other asset out there, the cash benefit of a death benefit for life insurance, right, would serve to prevent that problem so that that closely held asset doesn't have to be liquidated. We have the liquidity elsewhere. And Mark, would you like to take over this slide here? Can't remember if we discussed doing.
Yeah, no, that's fine. We can do that. So the benefits of the ILIT are very much as Grayson just said. I recognize that first bullet point, life insurance proceeds from the ILIT are federal estate tax free. We should have added probably just estate tax free, right? This would also apply for Washington State as well. This assumes, of course, that you created the trust properly, right? And one of the main problems that we have are really two things. First of all, people don't realize that they're supposed to not pay the premiums directly, right? So they just basically go, oh, okay, so I've set up this trust. There's a $30,000 premium I'm supposed to pay every year. So Jay and Daisy write out a premium that's directly from themselves to the insurance company. And they say, well, we're not the owner, right? We're just paying the premiums. We're not getting any benefit out of this. But the IRS says, aha, not so fast, because you're keeping the right to make premium payments in your own hands. We're going to call that an incident of ownership. You're the one making the premium payment. So that's a big no-no, which gets us into the problem of how do we make premium payments? Let's talk about that in a minute. I just want to mention one other problem that often comes up, and that is somebody says, Grayson, you know what? I just got $1 million policy last year. I just got a whole life $1 million policy. Can I just throw that into an ILIT? What's the problem with that? That's a question.
Yeah, perfect.
Yeah.
Okay. The problem with that is that it will work, right? There are ways to do it in the opposite way, that you have the policy first, then create the trust, then move the policy into it. But it's the second best method. The best method is to have the trust, and the trust itself, without your direction, is the one to buy the policy, probably on your life. Now, the
Yeah.
risk with that first plan here, if you have the policy, then create the trust, then move that existing policy into the trust, is that the IRS under Section 2035 has this clawback that says, okay, we will let you do that, but you better survive for at least 3 years.
You bet.
And if you don't, we are going to undo all of your hard work over those not quite 3 years to say that you haven't done anything at all. This is dangerous if trying to do something like this in expectation of imminent death. We know that it's probably not going to work, but even then, simply the risk, right, that something could take out even the most healthy of us at any given time means that we don't have a lot of certainty, the same way we do in the first idea, the first plan, that this is actually going to work, not until we know that we are one day past that 3-year window. And of course, as attorneys, we do put together that type of plan all the time. It's not our favorite one. We
Right.
prefer to have the trust first, then buy the policy, but we understand that a lot of folks didn't have their life insurance policy with the expectation that it end up in an ILIT. And now that you have this policy in your name, yes, there are absolutely tools you can do with an ILIT to help protect that policy too. You just need to live for 3 more years.
Right. And the other issue is that there may be some fair market value of the life insurance policy that you're essentially giving away, right? There may be some cash or other value, often known as an interpolated reserve or value or something like that. So you'd have to go in and work with your attorney and your life insurance company through those issues. And you've got to commit to taking your vitamins and eating your Wheaties and not swimming with the sharks or any kind of dangerous activities for 3 years. And then the ILIT will work. So let's go back to the premiums. So we have this problem, how the heck do I pay the premiums? And the basic idea with this, right, is you get what's called a gift tax exclusion every year. Grayson mentioned $15,000 per person per year. But if I were to say, I'm going to give you a check for $15,000 this year, but I post-dated it to the day of my death, which I hope is not this year, but it's a long time away. The IRS says, wait a minute, that's not really a present gift. A gift means, here, you can use this immediately. Like you give someone a bicycle, you say, here, go use the bicycle. You give them a car, you say, here, go use the car. But you can't say, I'm going to give this for you. It's $15,000, but you have to wait 10 years or 20 years. The IRS says that's not a present gift, and they won't let you use that $15,000 exemption per person per year. So let's find out how a doctor named Dr. Crummy, Crummey, found a way to make this system work. Grayson, let's turn to the next slide. So first of all, while we're doing that, when Grayson and I tell people about crummy trusts and crummy notices and, the crummy letters, people basically start edging a little bit toward the door, assuming we don't know what we're talking about. But actually, this case crummy letters commemorates a taxpayer victory over the IRS commissioner way back in 1968. So what Dr. Crummy and his team figured out is they wanted to use the present annual exclusion. At that time, I think it was like $5,000. They wanted to use that and try to use that to pay premiums. So what Dr. Crummy figured out is, let's say, right, step number one, he wrote a check out. Unlike the Gatsby's, he didn't write a check directly to the insurance company. Instead, he wrote a check and he put gift, G-I-F-T, and he wrote the check to the Irrevocable Life Insurance Trust. The trustee of the trust was not Dr. Crummy, an independent trustee. The trustee deposited those dollars in a trust bank account. Now the trustee does something very clever. The trustee sends out a letter, often called a notice, to the ultimate beneficiaries. Let's say these are the 3 children. Trustee says, your mom and dad just put in this amount of money. You have this amount of time to say, I'm taking the money right now. I want to claim that money this minute. Usually that time frame is about 30 to 45 days. The idea is to give people a realistic opportunity to exercise their right to directly take the premium money that was put into the trust. So Dr. Crummy put in 5,000, trustee deposits the 5,000, trustee sends a letter out to the beneficiaries and say, we just got this 5,000, you have 30 days to take your portion of the money. Now, don't put it in writing, but everybody understands they don't take the money. Because if they say, oh, I'm going to take that money, then guess what? Mom, dad, Dr. Crummy, they don't put any more money into this, or they change their will or their life and their living trust, something like that, to say, I'm a little upset with you for doing something stupid like that. So people wait the 30 days. After that's done, now the trustee pays the premium. Why did we go through that rigmarole? Because the IRS said to Dr. Crummy, wait, you can't use that. That doesn't make any difference. And the court said, yes, it does. Because for 30 days or 45 days, whatever this notice period is, those beneficiaries actually did have a right to take the money immediately, not waiting until after you're gone. So it's very, very important. If you're one of our clients who does have an irrevocable life insurance trust, we always provide instructions, and we provide a copy of this crummy notice. Make sure that you're following this format when you're paying those premiums. Now, this assumes you're paying them every year. Of course, you could do a paid upfront policy, which is what some of my clients have been doing. They say, here's the total amount. We're just going to pay it off all now. But if they don't, they can use over time this annual exclusion amount. And this doesn't reduce your federal exemption at all. You can give, right, however much into paying the premiums. And if you do it correctly, it will not reduce your lifetime exemption. One thing to keep in mind, many times premiums are more than 15,000. What do you do then? Well, you may have more than one beneficiary. And so you can give this amount to each of the first tier beneficiaries. And these are basically, maybe you said equal shares to kids. And there are some other ways, if even that doesn't work, where you can work with your attorney and they can put in some language that allows you to even try to use some of the amounts you could otherwise give to grandchildren or nieces, nephews, whoever you've named down the chain. These are called Cristofani beneficiaries after yet another court case where the taxpayer fought the IRS and won. So we now have a way to pay the premiums. We have a way to pay them without actually affecting our lifetime exemption. And as we've talked about, then we can make sure that the death benefit, if we've done this right, does not go in large part or a majority part to the Department of Revenue and to the federal government. Next slide, please. Okay, so we talked about putting together the irrevocable life insurance trust. It's very similar to what you may have done with your will or your living trust. You'll meet with your attorney. They're going to ask you a number of questions, make sure we understand what's going on. They're going to look at things and go, well, here's the amount. Many times I have people reach out to me and say, look, I'm dealing with my financial planner. I'm dealing with my life insurance agent. Do we have a sense of what my possible exposure might be? And therefore, we're going to make sure that we're targeting, well, this is probably the amount. We all talk together and say this might be the death benefit. But then you're going to decide who's in charge and who gets the money and how they get it. It could be just like your will. Some people get the money outright. Other people get the money when when it's distributed out over time, or it's in a trust for them over time if they're too young or they struggle with money, just like in your will or living trust. So we have a question, Grayson, about ballpark. How much does it cost for an ILIT? Generally speaking, we want to warn you, this is a pretty sophisticated tool and it has to be done exactly right. And we're dealing with a lot of money here that we're trying to save. Generally speaking, I think we charge around 7,500 or so. Grayson, do you think that's about ballpark?
Yeah, so we could conceivably have it less than that if it's a very simple ILIT, but I would say, 7,000, 7,500 or so is probably what we're talking about to get all of those really good tax planning tools. And the reality here is that this is a little bit more complicated even than our cursory level discussion goes through. For example, what happens when those windows lapse? What happens at the end of the 30 days? There's a tremendous amount of legal technical terms that we've got to use and got to tweak with a lot of specificity here about your plan specifically. And as Mark knows, right, when he has me review his ILITs, I don't just look at the trust itself. I look at the plan for the policy. How are those premiums going to actually be paid over the coming year, however long that's going to be? And then what tools do we need to have already in the picture in the trust to tweak and to turn the knobs here and there in about 25 different ways specific to your plan, not just the trust itself, but the actual policy and the premium schedule too.
Right. And there's no, usually if it's a second to die policy, you have both spouses that are part of it. So there's not a great deal more for, having a couple versus an individual, basically. Okay, so let's then turn to, let's say, some more other options. You may say, well, okay, an ILIT might be there for all these different reasons, but are there other bells and whistles that I could even think about that where an irrevocable life insurance trust might help? Grayson, why don't you talk to us a little bit about a dynasty trust?
Yeah, so this is now talking about a little bit more than just planning for the instant of our death now. We've talked in the past here now about making sure that we have this death benefit on the table, that we've got the whole value of it, not just roughly half or so, and that it can be available so that our beneficiaries aren't forced to sell assets that they would have otherwise wanted to keep, right? To keep in the family, the closely held vacation property or business property, right? That we can get the assets we want, not just the value. But then the question comes, well, then what, right? We've got that goal now at death, but let's talk about planning now for our beneficiaries, not just the instant of our death, but maybe even years, decades down the line. What is it that we want to provide for our beneficiaries and for how long? As soon as these strings fall away, as soon as this goes outright to your beneficiaries, it is theirs. And it could be subject then to a divorcing spouse, a predator, a creditor, even that beneficiary's own bad life choices, right? As soon as the strings are off, that means that it is outright, it is theirs, and can then be taken from them. And even if none of that happens, right? Even if they live their life with the benefit of that death benefit now in their name, distributed from your trust at your death, at their death, at the death of your own child, decades down the road, they may have their own estate tax problem that you have simply added to, right? Let's say your child is a doctor and doing really well for himself, or an engineer, right? Or has married someone of a similar type of background, right? Where now, for their own life, they've already had this estate tax problem ready and waiting to go. So if we have given this death benefit to them, and we've managed to, with this type of more sophisticated planning, solve the estate tax issue on your end, it's still there ultimately decades later at the death of your child, and so on and so forth. That is the way that the IRS, the Treasury Department, and even Congress see, I'll say, the natural transmission of wealth. It should be taxed in your estate to be passed down to your kids, where at their death, it's going to be taxed at their estate, so on and so forth, down to your grandchildren, great-grandchildren in perpetuity. And so we have plenty of tools available at our disposal to upset what these taxation entities view as the natural order. Specifically, we can put something in trust for the benefit of your child. It doesn't have to necessarily go directly to them. Yes, you can still get all those benefits that we talked about before through the ILIT, but we can still hold it for their benefit to make sure that it provides for their maintenance, their education, support, and health, maybe a vacation or two a year, maybe purchasing a primary residence, giving them a lot of beneficial interest without it necessarily being theirs. And if it's not theirs, that's the rub, because it won't then be taxed to them unless it is theirs at their death. That's how we avoid the second set of estate taxes, right? As I said, each generation is supposed to, according to Congress, Treasury, and the IRS, each have a shot at having estate taxes levied on the value of those assets moving down generation after generation. And so if we put this in trust for the benefit of your kids for their lifetime, we have skipped their estate. We've said, actually, the death benefit is not just going to be non-taxable to us at our deaths, the starting generation, but that death benefit will be there for the benefit of our kids and won't be taxed at their death too. There's no reason to cap it there unless you say so. We can do the same thing for grandkids, that death benefit still be there for your grandkids too at the death of your own children, and that at their death, their estates won't have to pay any estate tax either. We can do this in effect in perpetuity. Washington law says that after 150 years of something like this, they'll check in and see if it's still going, right? And then at that point, if it's still going, they'll cut it off and distribute it outright. But let's be honest here. That type of law is just as likely to change in 150 years too. It may not even be there. We don't know. And the idea is that we have at least 150 years under current law where we can keep this going down generation after generation after generation, and not so much as a single penny would be owing at the death of any of those generations, right? Not for estate tax. We are trying to avoid their estates to give them the benefits during life without the consequence here of an estate tax at their death. Now, with this in mind here, it's starting to trigger another nasty tax, the generation skipping transfer tax, which was actually, believe it or not, created during the Reagan administration in 1986. They saw how the Rockefellers and the Kennedys of the world had constructed these trusts and what a great deal it was by 1986, where we've now seen multiple generations benefiting from this without so much as a single dime going to the federal government. And so Congress thought this was wrong, that we should actually have a limit to how much we can give down through multiple generations in such a way that's not going to be taxed to them before we trigger this other tax, this generation skipping transfer tax. So right now, that generation skipping transfer tax is exactly the same as the federal estate tax. It's another $11.7 million magic number. And it's also taxed at the exact same rate of 40%, the same as the gift and the estate tax rate. It has not always been that. And so we're not going to assume in the future, too, that it will always be that way as well. But it is now. And so this type of tax planning concern, right, we've solved potentially the gift and estate tax problem, but now we have the cost of a generation skipping transfer tax, requires us to be very, very detail oriented to make sure that just as you got all of the value of your estate and gift tax exemptions, so too can you get all of the value of your generation skipping transfer tax exemption too. As best as we can, as attorneys, as professionals, we want to make sure that we don't run afoul of that third and equally burdensome tax too, that only really shows up in most cases when talking about dynastic planning, where we are literally skipping a generation, specifically their estate, right? That this will not be taxed to our children, and therefore has generation skipping transfer consequences. Now we have to be very careful with our exemption amounts to make sure that we have allocated enough exemption, and when and where and how during those years, during that premium schedule, to make sure that it can continue having these estate and gift tax benefits while also not having any generation skipping transfer tax problems as well. Again, that's another 40% tax that we would be looking to making sure is not going to, as best as we can anyway, with your 11.7 exemption, not have to be paid here at any point down the line either. And if it does, if for some reason we've got more than 11.7 million of exemption, we do have other tools to help solve that problem too.
Right. Thank you, Grayson. So there's a number of questions. Mostly, I think most of these deal with the whole life insurance problem, right? It is the case that in order to do this, you would need to be, eligible fiscally and physically to get life insurance. So I think there's some questions about, well, what if we can't afford the premium? That's a bit of an issue. You may have to, if you're using this specifically for estate tax burden, you may need to talk with your attorney and say, what are other tools I could use? Or is a small policy enough? Or do I have enough liquidity in other ways? If I think there's a question on, what if I don't have insurance? And of course, then the ILIT isn't going to be applicable. If you have no outstanding debts, your bills are covered, you have liquidity, and you're not worried about estate taxes, maybe it's not an issue then. And we've got a question about, do we have any kind of people we could recommend, any agents? The answer is yes. We've worked with a number of them. Unfortunately, they don't give us a kickback. They're just people we've worked with. If you want to send us an email and say, hey, could you send those along to us? Allie or Grayson or I could do that. And then finally, there's a question about, are the ILIT or dynasty trust exempt from income tax associated with the trust income? Not really, no. But remember, the ILIT doesn't really have a whole lot of income. So the ILIT itself, when you're around, is basically holding a little bit of money to keep the bank account open, and then it gets the premium in. It holds that premium for 30 or 45 days during the crummy notice and makes about, 78 cents of income, and then it basically uses that. So there's no real income for most ILITs to speak of while you're still living. Many ILITs, this is a little far afield, but while you're living, they are created as something called a grantor trust, and that's this slide right here, the differences between an ILIT. So let's turn to the ILIT column. We talked about this, the trustee can't be you. Obviously, the term is for your lifetime because we want the death benefits to go to the next in line, not back to you or your spouse. The type of trust is called a grantor trust, meaning it's taxed at your taxable rate, whatever the income is. The proceeds of the insurance would not be subject to income tax, but here's where that estate tax, that's the big issue we're talking about. So I think those are most of the questions I've seen. Forgive me if I didn't cover one. Grayson can look and see if I neglected
Mark,
an. Yeah, please.
if I can add just a little bit here to Bob, I think you asked this question about the income tax consequences. What we tend to prefer, right, once that dynasty is actually, the dynasty trust is actually going, so after the point where the ILIT has already worked to protect the death benefit, now we're talking about the death benefit in the trust for the benefit of the kids and maybe grandkids going down the line. We generally like to have trustee discretion to distribute the ordinary income at that time. So Bob, as you noted here, trusts often pay more burdensome income tax rates. It's not because the actual brackets themselves are any steeper, although they are ever so slightly. It's because the brackets hit at a much quicker rate. So you're paying the highest possible income tax on only $13,000 of income. As you know, that's not a good answer. And because that's not a good answer, we typically want the trustee to be able to, if it's the right answer at that time, solve that problem too. We don't force the answer, right? Bearing a little bit of income tax may be the exact right answer to get all of the good beneficiary protections, right? But if there are no other concerns, in most cases anyway, the ordinary income during this period where it's running for the lifetime of your children or grandchildren could be distributed out to them. And if that ordinary income is actually distributed out to them, not retained in the trust, then the trust simply passes it through. It gets an item for item, dollar for dollar distribution deduction. So if there's $100,000 of ordinary income and $100,000 is distributed out of the trust, you do have to technically file a tax return, right, to say just that it got $100,000 and it has a $100,000 income distribution deduction. Congratulations, no tax owing. And what that's done is it's now ported out that income tax liability onto your beneficiaries who pick it up and pay the income tax on it as individuals. And that's for an income tax plan, right? Usually the right answer. And what we're saying here is that as best as we can, if that's the right answer at that time, subject to trustee discretion, we don't want there to be any more income tax consequences than the bare minimum, right? Yes, income's going to have taxes paid on it, but if we can pick and choose when and where that tax is going to be recognized, at what entity level and at what rates, that flexibility is the best way to solve that problem.
Thank you. All right, so we're going to then deal with one more possible option, right? I'm not going to dive into this in any degree of depth. I just want to describe to you a possible problem that some clients have and the ways in which we can try to make different types of tools work together. What oftentimes is the difference between someone who's good with a hammer and a carpenter is, right, to a hammer, every problem looks like a nail. But to a carpenter or a craftsman, there are different tools for different types of purposes. So let's pretend we have this situation. Let's suppose that Mel and Melinda, right? Remember, we met them early on in the seminar. They had about a $4.2 million estate or so. Let's suppose, for the sake of example, that a fair amount of their money is actually in an investment that Melinda made in a little startup company called Microsoft. Let's suppose she put the money in way back when in the 80s, and she had, $50,000 worth of an investment. And now that stock is worth, let's just round ballpark, let's suppose it's worth $1 million. So, right, they're thinking, well, wait a minute, we have all this Microsoft stock. What do we do? We want to deal with this in a way that we're not going to get hit with capital gains tax if we sell it. And of course, capital gains tax may be 15 or 20%. There may be an Affordable Care Act surcharge of another 3.8%. So we're talking about a significant hit on that $1 million of Microsoft stock, because we had this large appreciation since the time of Melinda's first investment. Well, it turns out, let's say Melinda is interested in a few charities, and she feels like, I do have a charitable commitment. There is an option for her and Mel and her husband, I think it was Morton. So there's an option for them where this option is called a charitable remainder trust. And some of the benefits include, by doing it correctly, we could get some income tax deductions for them. We could give them or one of their children or someone they chose a stream of income for a certain period of time, either 20 years or their lifetime. And whatever money eventually goes to the charity then will be outside of their taxable estate. So we're getting estate tax advantages, we're getting income tax deductions, we're getting a stream of income, and we're also benefiting charity. So the one issue then that you'll often hear is the charity must get something at the end of the term. There's a couple mathematical or actuarial tests that need to be done, and we don't need to go into that, but the charity is supposed to get whatever's left after the term. So let's suppose we're talking to the couple, and we say, oh, good news, we have this tool for you. And they say, wow, we'd like to bring our kids in and talk about this. And so we go through, we say, hey, there's an income tax deduction when they do this. And they say, yes, that's fantastic. We say there's an estate tax benefit to doing this. They say, wow, that's fantastic. Grayson, you're a genius. And we say, okay, and your charities are going to get benefited as well. And they're like, this guy's the most amazing attorney we've ever seen. And then we say, you know what? The charities will eventually get some amount of money, $200,000 of whatever's left. And the kids go, wait, what? $200,000 of our inheritance is going to a charity? Suddenly Grayson has fallen off his pedestal. So the idea then is we can combine an irrevocable life insurance trust, use it in tandem with this charitable remainder trust to make up for that lost wealth, the wealth that's going to those charities, we can say, that's what our death benefit's going to be. So we can do all this and make it work together. So let's look at the big picture. Next slide, please. Okay, so this is how, in theory, it would work. I know this is a lot to deal with. We're just dealing with big picture. I'm actually dealing with a few clients that we're looking very seriously at this structure right now. But number one, of course, 1A in the upper right-hand corner, we're establishing the charitable remainder trust. We get the deduction. I forgot to mention, we can, as soon as we transfer that into that highly appreciated stock into the charitable remainder trust, it could be sold right after that. And since this charitable remainder trust is a tax exempt vehicle, we don't have to pay capital gains tax. So we've lost it, we've missed out. We don't have to pay the capital gains tax on selling this highly appreciated asset. We get an income tax deduction. We minimize our estate and gift taxes. Of course, we have to have that ultimate charitable intent. So we transfer this $1 million of stock into the charitable remainder trust. Number three, that's when we sell the stock or the house or the business, that highly appreciated asset. Each year, the charitable remainder trust has to make payouts. Usually it's back to the person who created the trust. It might be to kids or someone else, right? Then if you're getting those payments, remember all that business about you write a check out and make a gift to the irrevocable life insurance trust? You're using the payouts from the charitable remainder trust to pay those premiums. You've established that irrevocable life insurance trust, the whole business with the crummy notices, everything like that. When the term ends, usually when you die, right, then whatever's left in the charitable remainder trust goes to charity. But at the same time, right now you've got that death benefit from the irrevocable life insurance trust that is there to make up for whatever might have gone to the charity. So that's a possible tool. What we're trying to say is, remember, you're looking at the irrevocable trust as another tool in your tool chest that you can use. It doesn't have to be just this standalone vehicle. It can do all kinds of things for taxes, wealth replacement, you name it. And with other tools like a dynasty trust that Grayson talked about, or a charitable remainder trust, we can actually get some really substantial advantages without necessarily, taking money away from anyone other than, if you'll pardon the use of the phrase, the IRS and the Department of Revenue. All right, so Grayson, you want to bring us home now?
Absolutely. So thank you for everyone here who's joined us for this seminar. As you saw, we were able to go through quite a lot of the more high-end, more advanced planning strategies having to do with life insurance policies. And really, we're hoping that what we were able to present to you is that, yes, there are tools, absolutely, that are available to you if any of these problems exist for you. We want to encourage you to come talk to us. And as attorneys for the last, 53 odd years that we've been in practice, right? Not me specifically, right? But the firm generally. We have never, ever charged for these types of initial appointments. So if you'd like to come in, schedule a time to talk to myself or to Mark, or both of us if you prefer, we'd love to talk to you to see whether even this is something you should consider. And if so, how you would like the nuts and bolts of your plan to work. We talked about this in very, very broad brushes, but we can tailor almost everything that we went through to your specific concerns so that we can get those benefits that are more integral to you and your planning done as well. Now, we've got 2 office locations. We're located in SeaTac and we're located in Bellevue. So whichever is easiest for you, we'd love to see you there as well. Now, I think we have a few more questions here we'd like to get through, and Mark and I will stick around to see if anything else shows up as well. The first question here, it seems from Donald. When will the slides be available on your website? Ideally, as soon as possible. As soon as we finish this webinar here, we're going to have the slides hopefully uploaded there. And potentially, we'd like to also have the recording available too, so that if possible for you all, that you can actually go back and see this.
Right, because it's far better than most Netflix or Amazon Prime series you're going to want to see. It certainly will be better for your beneficiaries down the road, I assume, to take a look at it. I don't know if these will be on the website or not. I'm not certain if Allie's thinking she'll email
Mhm.
them out, so it may be one or the other.
That's true. Good call, Mark. It may actually be sent to you directly. Okay. Any other questions for us? I'm going to leave this running here probably for another 5 or 10 minutes or so. And if I see anything else show up, I'm happy to turn my screen back on and see if we can help answer those questions as they arrive. Otherwise, though, just thank
Right.
you again. We appreciate your patience. It's a very, very beautiful sunny day. So it means all the more to us that you chose to spend at least a little bit of that with us.
All right. Thank you all, and we'll talk to you soon.
Take care. And remember, we are still here. Hi, Kathy. I'm signing back in here to see if I can help answer your question about, the topics and what the meeting is actually going to look like here. So we would talk about all of this together, ideally in one meeting, but if we needed more time than that, we're happy to give you as much time as that would take. We want to be able to go through this, not just issue by issue, but the big picture here as well, right? What is your goals and how can this plan accomplish that? And so that's exactly why we'll be trying to go through as much of this as possible then in that single meeting. All right, I'm going to sign back off here. Hi, Julie. I see your question here. So I'm not 100% sure necessarily what type of trust you're talking about. So I'm not sure I'm going to be able to answer kind of the order in which documents are created, but generally speaking, we always want to start with the core of your plan first, right? That we get all of the easy, low-hanging fruit taken care of. That is basically using a will or a living trust to accomplish your goals. And in a meeting with us, we can go through a lot of those pros and cons for you specifically to see whether either one of those tools makes more sense than the other. Sounds like you say you're creating a trust. And so if you do go with a living trust, for example, as opposed to a will, that's a type of strategic choice that you would be making at that time. And what we were talking about today was about once that is done, once that core of the plan is in place, whether that be will or living trust, now we need to start caring a little bit more about some of the one-off or two-off issues. For example, these issues that we talked about that are unique to life insurance, right? And how we plan using those unique features for life insurance specifically. And so we talked about now, let's say you do have a revocable living trust, or you will in the future. Once that's in place, you can then use something like an ILIT, even if you have a life insurance policy already. Right, as I mentioned, yeah, you can do it. Second best plan. The idea being that you can then create the ILIT and move the policy into it. And so long as you live for those additional 3 years that is required to get that to work, that's a great method, right? In that order, living trust, then the ILIT, in order to help accomplish not just the general estate planning goals, but even these goals having to do with our life insurance policies as well. All right, I'm going to sign off here probably in the next 2 minutes. Hi, Bob. I'm so sorry I missed that question. You're right. When I was looking back here, I see that you had asked specifically about the recording of the presentation. Yes, we're going to get you not just the slides, but the recording too. I'll have Allie Humphreys, one of our admin assistants, work on providing that to all of the attendees here for this meeting. Again, not just the slides, but even the recording of this presentation. Okay, with that, I'm going to sign off now. This is probably going to kick you all off here in the next few seconds. Thank you so much. You've been a wonderful audience. Take care.